Again, I'm Cameron Azari. I'm with Epiq. I'm a senior vice president. In the United States, I'm recognized as an expert in notice and claims administration programs. Consult with the clients and consult with the court on how to do the plans. I've got Steve Weisbrot over here to my right. Steve does a very similar thing to what I do. Steve's internationally recognized class action notice expert. He's known for his innovative data-based media plans. He regularly writes and lectures on class action notice and is a widely sought-out speaker to address industry conferences. To address industry conferences across the globe, as well as bar associations and private law firms. Again, there's more information here on Steve. And then Scott Hardy. Scott's with Top Class Actions. Scott formed Top Class Actions in 2008 because he saw a need to consolidate and clarify class action news in a consumer-friendly and organized way. And then I have Tighe Wilhelmy over my shoulder here. Hi, Tighe. Tighe's coming to us from Arizona. He's the co-founder and CEO of Velawcity, the legal advertising network providing case acquisition and administration services to law firms, nationwide for mass tort, class action, and mass arbitration lawsuits. So, first of all, I know I speak for the guys on my right. We're really pleased to be here. We've missed coming to London. We did this virtually last year, which was fine under the circumstances, but this is so much better. So, we're really pleased to see everybody here. What the four of us do, primarily in the context of complex litigation, is provide notice and communicate with class members and prospective claimants. So I think we want to talk a little bit about that today. We're going to have a free-flowing discussion. We encourage questions, so hopefully people have some questions. And it was interesting, I think, we chatted, the four of us chatted briefly a few minutes ago. It's interesting to see the panels earlier in the day all touch upon nuts and bolts, practical aspects of doing this, of maintaining class and collective actions. We know it's an interesting topic. The first thing we want to talk about is communication, though, with our class members, and in really communication with prospective claimants. And one thing that struck all of us when we're talking about communicating is there are really different kinds of communication, different goals. There's communication for book building, reaching out to the prospective class members. And then there's also communication within the context of like a collective proceedings order, the due process notice. And those can be similar, but those can also be very different. And I'd kind of like to hear from the rest of the gentlemen on the panel about the book building piece. I know, Scott, this is a big piece of what you do. And just some comments in general about how you see that operating in your experience and just ways to do it more effectively.
Well, it's been interesting with Top Class Actions in the US. Now we've got Top Class Actions UK and Top Class Actions Canada. And as soon as we cover an individual lawsuit that was already filed, we'll get sometimes thousands of comments from people that are impacted by these particular lawsuits. And when we actually work with lawyers before that case is filed, we can get a similar response. If you come up to me and say, Scott, we want to go ahead and file this particular case against this defendant, we want to know those people that are impacted by it. We're able to put it in front of our large audience. Top Class Actions gets more than 1 million people a month, sometimes upwards of 3 million people a month. And these are all consumers who are actively engaged and interested in participating in the legal system. They're not like on Facebook, and a lot of people are sitting there running ads on Facebook or Google that are just sitting there to watch cat videos. No, these people who are on Top Class Actions are looking for justice of some sort, whether they're looking to submit a claim, whether they're looking for a lawyer for representation. That's the type of engaged person that you would get. And it's as we've continued to grow, and as we've talked about, and many of the panel members earlier have spoken, the chase to go online and to find what you're looking for is incredibly active. Some of our campaigns now get 20,000 plus opt-in members per month. And that's all organic through an active engagement campaign, through email, through social media, and of course, just writing engaging content.
Yeah, that's really interesting, Scott. So Tighe, I mean, this is interesting how this leads into an active piece of litigation. Tighe, what are some of your thoughts about, I know you mentioned important to see this in a holistic way, going through each piece, through the book building piece, onto the claims administration piece. Can you maybe tell us a little bit about what you do and how that feeds into that process?
Sure. Yeah. Thank you, Cam. And sorry, everybody, that I can't be there, but I'll do my best to bring value to today's session. A good segue from what Scott just had to say, unlike his organic approach, we do take more of a paid advertising approach to our acquisition efforts. And once that process is complete, once we've tapped into the appropriate channels, depending on where those universe of cases live, whether that be traditional or digital media, we begin our actual intake efforts, or the sign-up process, if you will. And from that point, what are the different treatment methods for those individuals? Are they best reached based on demographic by SMS? Is it outbound dialing? Is it email? Is it a mixture of those things? Are we creating unique cadences to best get in touch with those individuals? So I think the point to hit home is that there is not one kind of cookie cutter solution for communicating or creating treatment plans, as we call it, workflows to establish communication in a healthy manner in an ongoing basis with those clientele or with those claimants.
Thanks, Ty. So, Steve, I'm going to turn this over to you a little bit and talk about the due process piece. I know that you've been heavily involved, obviously, in the U.S. and over here in putting together these plans. So, can you talk a little? You don't have to hit this directly. What I'm asking in terms of differences between this piece and the due process piece, but tell us a little bit about what the thinking is when you're putting together a due process plan that's going to meet acceptance by the court.
Yeah, absolutely. Thanks, Kim, and it's a pleasure to be here as well. I think in reality there are two main differences between a due process plan and a book build plan or a claimant aggregation plan. The first, I think it's important to remember, in most of the countries with more mature jurisdictions around collective redress, that expertise like what I offer and what CAM offers really acts as sort of a cross-check on the attorneys at the time of settlement. Because what you have is a situation where two sides of a litigation had previously been heavily litigating a matter, had diametrically opposed views, and then ultimately come together at the settlement stage, and they are each interested for their own reasons to push the settlement through. And judges tend not to be as educated as some members of the public or private sector on what different media options are available and how to do them properly. So a lot of times when Cam or I are called into a case, it's to make sure that the judge feels comfortable binding all of the people, particularly in an opt-out jurisdiction, whether they've seen the notice plan or not, whether they've been served with an ad or not, they're gonna be subject to that order once the judge bangs the gavel. So in a lot of ways, that informs the type of plan that we put together. The motivation isn't necessarily trying to get someone to do something, but to make sure that they're aware of their rights. So in a lot of ways, when we express via a notice plan document, an affidavit, et cetera, to the court, what it is we've done in a due process notice, the focus is, did people have an opportunity to see the media, and what did they do with that? Now, contrast that obviously with a book build, where you're trying to get as many people in the door who are going to raise their hand and say, I want to be a part of this litigation. And therefore, you're going to do a lot more like what Tighe was saying in terms of figuring out the demographics, the psychographics, and the habits of the people you're trying to reach. And it looks very different across cases, as you all know. Trying to find someone who bought a diesel emissions vehicle even from Mercedes versus Volkswagen, you may be using different types of media or at least different particular publications because your average Mercedes reader is going to read something different than your average Volkswagen reader. So there is definitely a bifurcation, but it's kind of a Venn diagram in that some of these best practices exist in both worlds.
Yeah, that's a really interesting point. I think, Steve and I have been doing this for a long time, and in my opinion, in the United States, that's where I'm from, so I'm going to speak from that context, there was a long time of focus on the due process piece, which is important, as Steve just described. It's incredible because it's an opt-out regime. We have to give people the chance to find out about it because their rights are going to be affected if they don't take any action. I think for a long time the focus was too much on that, and frankly there was a little bit of dismissive, I think, by the courts and by attorneys on the work that Scott and Tighe do, in terms of that really going out there and reaching out to people who are interested. It's not 90% of the class, I don't think. It's a smaller percentage, but they're the ones that are going to participate. And I think good communication plans that we do now have aspects of both. We really have to do that, make sure that we give everybody an opportunity, but also really be smart about focusing on those key groups that have already, like Scott said, have expressed an interest. They're already interested in legal proceedings in general. They're the ones that are going to participate and perhaps file a claim, because a lot of the success of these litigations when they're done are going to be judged based on how many people participated and how much money we were able to give back to people.
Well, and it's when you talk about getting people to participate in these lawsuits, that was a key reason why I created Top Class Actions, is to educate people and try to tell people these are worth your time. People would sit there and say, oh, Scott, I get that notice and I just throw it out. And so we're trying to turn things around, especially in the coverage that we're putting out in the UK, is we're trying to make sure people know that these cases are worth your time to participate in. Don't throw out the card, get signed up, because if the award is worth it, then you're going to get a much higher participation rate. And I think we'll be able to start on a positive note, especially in the UK, when we're trying to get people engaged and we try to educate people. So a lot of the content you'll see on Top Class Actions will be just talking about what the lawsuit is, how to participate, who's involved, and most importantly, why you should be engaged.
I want to speak to that if it's all right.
Yeah.
I found it very interesting, in particular, Stephen Jeremy's comments during the funding panel about it being so difficult to amass 2 million claims in a case. And frankly, I understand from a funding perspective how that presents risk and makes it perhaps less attractive when you don't have a proven model necessarily in the UK doing that. But anecdotally, that is not a terribly hard threshold to be able to reach in some of the more mature jurisdictions, the United States, Canada, Australia, et cetera. Just by way of anecdote, we are doing an administration now for actually one of the attorneys in the room where we just sent out over 2.9 million digital payments as a result of a data breach. It wasn't an incredibly high amount of money that these people were entitled to, but people who were predisposed to either hold corporate America or corporations generally accountable, or who had felt aggrieved, they made those claims. And I think that, yes, albeit there was money on the table at that point, I'll concede that that is a difference from a book build, but you can still create your messaging letting people know that there is eventually likely to be money on the table. Just also anecdotally, we started a very major notice program just yesterday in the United States involving a social media platform and some alleged wrongs that they did regarding biometric privacy information. And as of this morning, we started yesterday, we have 230,000 signed up claimants. That's in one day. Now, certainly not every class action is that big, and not every class action has that amount of people that want to get involved, but the idea that this jurisdiction and frankly all of Europe cannot, with the education Scott provides, with the types of notification that we all provide up here, whether that's geared towards due process or it's geared towards claim and aggregation, the fact that we can't have consumer or retail claims with millions of claimants signed up, I just don't believe that. And I think that time will ultimately tell whether I'm right or wrong, but it's certainly done every day in other jurisdictions. And structurally and procedurally, there are some ways that I think we can be more effective here, where we're essentially starting from the ground up. And I know Cam wanted to talk about that and has some really good thoughts about how we are just building this system when we have the opportunity to maximize it for efficiency and to maximize it for productivity. So,
yeah, that's a good segue. I mean, we've all been involved in the American system for a long time, which clearly has its good points and some bad points. And I know all of us here look at what's going on in the UK and Europe with the emergence of the class and collective actions. We look at it as an opportunity to do things better. Really to in terms of the notice piece, making sure we're communicating in a more thoughtful way. Also that we're designing the claims process in a more thoughtful way. It's an opportunity to make a first impression, I think, really here. And Scott, you and Tighe touched on this a little bit. I'm curious about how you guys, design your outreach efforts, whether it's through use of websites, through use of call centers, through use of building databases? I mean, what do you guys do in order to, what Scott, you were just alluding to make people feel comfortable about participating in these types of litigations?
Well, a lot of what Top Class Actions does is try to build that trust. And the biggest compliment that I received was when I had one of the plaintiff lawyers that we worked with said, "Hey, Scott, Jane Smith was just in my office and she says hello." I said, "Well, I don't know this Jane Smith." She said, "Well, what are you talking about?" She talked about you. She talked about your kids, Sydney and Aubrey. She talked about your wife, Barbara. How does she not know you? I said, "Oh, great. Well, she reads our newsletter. And our newsletter goes out to hundreds of thousands of people every single week. And I build that personal connection with these viewers so they come back more and more." Mm-hmm. And it's something that's an outreach that I think a lot of local lawyers miss out on, is that if someone hits your website and you're able to collect that data and get them on a mailing list, you can connect with these people. Mm-hmm. So now when we bring in 1 to 3 million people a month, a large portion of that is just through what could be considered old technology, email newsletters. And of course, we've got the organic outreach for people through Google and through our social media channels. But building that connection and building that trust is what keeps people coming back more and more and more. And so about 65% of our web traffic is new every month, but a good 45% of it are all existing people that are coming back to participate in more and new lawsuits and settlements.
Yeah, good point.
I'd like to brag on Scott for a minute. So all day, every day, I'm monitoring claims traffic across the 100, 150 live class actions that we have going on all different jurisdictions. Mm-hmm. And I can tell by watching our traffic when Scott has sent out his newsletter. Mm-hmm. So I think the idea that really hasn't resonated so far in the UK, at least so far as I can tell, is once there becomes a certain level of acceptance of the collective action regime, there are going to be people who are looking to file as many claims as they can, so long as they qualify and they're not committing fraud. A lot of people who come from lower demographics within the United States see this as a both ethical and effective way to supplement their income. And the claims administrators, and we could talk about this, do have ways, albeit not perfect, but very effective ways to weed out fraudulent claims. So while it's a concern that we have a solution for. And there becomes this subgroup of people who watch the class action market in the United States very carefully to see what they can claim for and what they can. And Scott's website is very good about explaining the requirements. And this is what you had to have bought this product between this state and this state. You have to live in this state or that state. And people know that if they don't fit into those stratum, they can't go ahead and file a claim. And I think that that coalesces with my idea that you can get millions of claims here. And I don't want to be too aspirational, but I think when you combine sort of what we've seen in these other jurisdictions and companies like Scott's, it's not as aspirational as it sounds.
Yeah, I agree with you. Go ahead, Ty.
Just to jump in and try and tie that all together, we've all been doing this for a long time. And for me personally, it's been about 10, 11 years. And even in that short decade, we've seen the market expand from anywhere from 5 to 10% of total universe of claimants that exist come forward to 15 to 20% in recent years. I think that's also supported in recent history, whether it be rule changes here in Arizona, whether it be changes on the horizon in the UK, as well as social acceptance of being a litigious person, right? Or social acceptance of going against the big pharma or the big corporation, or kind of leveling the playing field. The mediums and the forums to which exist today, whether it be some of these social media platforms or other outlets, are much more powerful. And that does lead to a mass opt-in, whether it be on something like Scott's website or engaging in some of the paid media strategies that we use. But nonetheless, technology, capital markets, social, I think have all played a significant role in expanding just the industry as a whole, right? And then from there, the concept of, Stephen, your comment about 2 million claimants, that makes my stomach hurt personally. Having to manage resources according to execute on that type of volume of claimants. We've certainly done significant volume, but when you start getting into those levels, I want to raise the conversation about how we go from companies like Scott and ourselves handing that baton off to companies like Cam, yours, and Stevens. I think that's an important element of the conversation to be discussed, because any inefficiencies there typically can result in a lot of problems for both organizations, or inefficiencies in the due process claim overall.
Yeah, it's a good point. And listen to this. I think in my career, a lot of attorneys and courts, I think, have been a little dismissive of the type of work that Scott does. I think that it's been, frankly, a little bit of an elitist perspective, because we're talking about consumer claims here in this context. We're talking about, people who may be out $20 or $30, which may not seem like anything to the people in this room, but that's something to a lot of people. And if we're not using these tactics that are available to us, we're missing getting people to have an opportunity to participate and receive money. And I think that the fact that the industry has become, over the last 10 years, much more open to this process, I think has only been good for the class action device. Because the purpose, as somebody mentioned earlier, the purpose of this is to make sure that a defendant company can be fined, but there has to be a mechanism for people to get their damages back, and this gets money in the hands of those people.
And the great thing about these consumer claims that was touched on by earlier panels was you can go ahead and tell what that damage is by person. And so depending on the product and the defendant, you can go ahead and say, hey, this was an impact of X dollars per person, and let's drive that forward. And if you can give that positive message out to consumers that it's worth their time to submit their claim and get involved, or it's worth their time to sign up so this case can proceed, I think that's going to provide a monumental positive impact for this type of litigation in the UK and beyond.
I also think, and this is totally aside from what we're supposed to be talking about necessarily, but I think that the value of data, Lloyd v. Google notwithstanding, in the UK and in fact across all Europe, even evidenced by the fact that there is a statute like the GDPR. And in the US, it's just a patchwork of different state statutes. There's no nationalized privacy statute. I think is going to lead to creating a value for data claims over here that's in excess of what we might be seeing in the US. It's certainly something, at least from my perspective on the outside looking in, a right that is that is taken much more seriously by the populace of most European nations than it is in the United States. And I'd be very interested to see 2, 3, 4 years from now what the value of a data breach claim is over here compared to what we're seeing on average in the United States.
Yeah, I'm interested. I think the next panel, they're talking about
So I will
John's
stop
panel.
talking about that.
Yeah, no. It's a good segue to that panel, because I'm curious to see what those folks have to say because of that decision. Another thing in communication is plain language and putting things into the mode that people will understand. And plain language to me means more than just getting Latin out of it and making sure it's written at an appropriate comprehension level for people, but it's the communication mediums that are used. We had someone mention earlier and hold up, this thing's kind of a big deal in terms of communicating with people. And I'm curious for the rest of the guys on the panel here. I mean, what do you see in terms of just plain language in general and appropriate ways to communicate with either prospective class members or class members in a case that's already proceeding?
I can jump in and give a quick example on our experiences. Geographics are huge in the U.S. Our conversations typically last 20, 30 minutes on the phone before qualifying and signing up an individual claimant. Now, when we get to the sign-up process, those who are anywhere but the Bible Belt, and for those who aren't familiar, that's your Alabama, Mississippi, Arkansas, you name it, are totally receptive to a e-sign process, whereas the thought or mention of such a thing in the Bible Belt within the United States is totally rejected. If it is not a physical contract mailed to their front house, they will not entertain signing up for that process. So I think that's just a quick high-level example of some of our experiences that are a little entertaining in my opinion, but things to be cognizant about.
Tighe, do you see the same sort of differences according to age in terms of acceptance of digital contracts or other digital advertising?
Absolutely, absolutely. Older demographics are certainly going to be looking for more physical contract receipts than your younger demographics. Good case in point, though more of a mass tort would be a 3M versus a talcum powder. Average age of your demographic in talcum powder was north of 65, whereas 3M was closer to 40, 45.
Yeah. Interesting.
And so when we're writing this content for people, we've always made sure that we're writing from a consumer's perspective. And so when we're writing about a class action settlement or a case that was filed, I get on my journalists and my writers and my editors to keep it simple. Because when we started this 13 years ago, all of the content that was out there was from a lawyer's perspective. And it was full of legalese, and it wasn't as simple as it should be. And we started just breaking down these cases and just saying, this is who qualifies, this is how much is at stake for you individually, and this is what's going to determine, what's going to happen going forward. But we try to keep it very simple, because now people are used to consuming content in bite-sized increments. And so we have to be more and more poignant on each individual element, because they just want to sit there and read that and understand it within 2 minutes. We can't sit there and give them a 10-minute long piece of content.
Right.
Now, I'm going to play devil's advocate, if you don't mind.
Yeah, no, good.
That works in the book building stage, but how do you answer critics who are going to say, well, was due process really achieved if you only give them that bite-sized piece of information? Don't they need to know what the case is about at a very detailed level, what options they have? Can they opt out? Can they object? How do they do that? And maybe, to answer my own question, maybe that sort of delineates the line between what Cam and I do and what you both do, because it's our responsibility is to the court to assure them that these people know their rights and have acted meaningfully when we're acting as notice experts as opposed to helping on a book build. But I mean, do you have any other thoughts on that?
Well, because my point is always to get in front of that consumer and say, this might impact you. You might qualify for this. Yeah. Get engaged. And when they say, well, I've got questions about if I actually do qualify, I say, talk to my friends Cam and Steve. They're the experts in litigation on this. But I'm just trying to get that initial eyeball right there to get their attention.
Yeah. It's interesting. This is all, I agree with everything here. And what this tells me is that putting things in plain language and communicating is hard. It's a hard thing. It requires effort and planning. I always advocate to my clients that it's incredibly important to talk. It doesn't have to be me. Like, find somebody that you trust, but talk to somebody early and really think about this entire process, because all these pieces are important. There's thinking about what the demographics of the class are incredibly important. And making sure that we get the initial communications in something simple and plain language are important. And making sure that our websites and our printed documents and everything, are eye-catching and get that critical information out quickly, but then provide all the detail. And make sure it's very clear people can go to a website or wherever, they want to read the complaint, they can go find the complaint. All this stuff is not to be done at the last moment. It's to be planned out and done in advance. And one thing I really enjoy about the regime in the UK is having the opportunity, frankly, to document this all up front. And to me, it's important. And I'm glad that piece is required. It's a lot of work and it's a lot of effort, but I think it makes for a better litigation overall, in my opinion. I don't know what you guys think.
I agree 100%, and it's a sage point. And Jerry Spence, famous American litigator, trial attorney, one of the best trial attorneys probably in the history of America, in his book talks about how before any trial, a couple months before, he starts going to local bars that are outside of the jury pool or pubs, and he tells the story. of his case, and he hears the types of questions he asks, and he hears the way that the questions are phrased. What are the local vernacular and how they're describing something, and then he weaves that into his opening and closing, which I always thought was interesting, and I think jives with what Cam is saying. You know, talk to the people, let them ask their questions in anticipation of filing your notice plan with the CAT.
So I'm cognizant of time. I know that we started late and I know lunch is coming up, but I want to touch on one more topic briefly because it was mentioned earlier by the funders, and it's a good one, is cost. You know, notice is not cheap all the time, right? And the whole process, not just the notice, whether it's printing and mailing notices or sending emails or doing media and social media, those sort of things, but it's the communication that's going to occur with the potential class members. It's people making phone calls and sending emails quite a bit. So I'm curious, you guys, what are ways to make things run more efficiently at this stage?
Well, I'll throw a softball over my buddy Tighe up there on the screen. Is that something to keep in mind when you're advertising for clients? Pay-per-click has about doubled in price over the past year. And that's going to continue to double as more institutional money comes into play. And so if you have a good organic method of reaching out to people, then that's going to save your firm a lot of money going forward. And having those things like building newsletter lists out, writing regular content that talks about the types of cases that you're filing to really drive engagement with potential members. And then Tighe, because you know obviously you do a tremendous amount of paid advertising. How do you see that changing this year or next year?
I mean, it's certainly going to increase with some of the changes here in the States and some of the opportunities on the horizon in the UK. We kind of bifurcate the process, right? You've got your cost per acquisition, and then you've got your cost for administration or notice. And the acquisition cost is a pretty simple equation, right? X plus Y equals Z, and is that going to be economical based on the projected returns once subtracting all the administration costs? And as far as the administration or the treatment plans, the communication regarding notices, as much programmatic communication as we can establish, the better. But there's obviously an element of outbound dials that may need to happen at some point. One of the areas that we've seen a lot of development in recently are voting systems. That's something that's made its way into many niches of law, whether it be environmental or class action. PG&E settlement was largely built around a beautiful voting system that I thought took a lot of time, energy, and preparation, and ultimately saved those firms a lot of financial investment. So I think technology, especially here in some of the sandboxes like Utah and Arizona, has reduced some of those barriers to entry in terms of cost with the administration side of things. And that part's exciting, but there's certainly a lot of work to be done. We're not there yet. Mistakes will be made. And we just have to make sure that we've got enough of our minds in one spot to work through those issues or obstacles.
Cam, do we have time for me to jump in on that question real quick?
No, go ahead. I'm sure we do. Nobody's waving their hand at me.
Okay.
We have 10 minutes. I would just show. So.
Okay. So one of the things regarding cost that I think is very important to think about, and in particular for the funders to think about, is everyone is very reticent to put a lot of upfront costs into a book build plan. I heard someone talk about seed funding, and let's throw 20,000 pounds on it and see how we do. And from my perspective, and I would love to hear from my co-panelists, that's about the silliest way you can treat a book build. And the reason is, we use a term a lot in our planning called integrated, which means that one thing feeds off of another in media. For instance, we might run a TV commercial. No one remembers the exact website you're going to go to, so they go and they search for it on Google, and we have search engine marketing going so that once they're searching for something as a result of your commercial, they then find it on the internet. And everyone seeks to really keep these costs down, and so they're not getting an accurate portrayal of how well a media plan can do where all cylinders are firing at the same time. And I've been involved in a number of different book builds in the UK, in the Netherlands, in France, in Belgium, where the funders took the position that, let's just do a little at a time and see how well we're doing. And it wasn't until I beat on the gong long enough saying, listen, let's let the floodgates open for a month, do everything at the same time, then everyone was like, oh, this really does work. So I would just caution you when you're going out there not to be penny wise and pound foolish, because that is what does happen when you do media in dribs and drabs. It's greater than the sum of its parts, I guess is what I'm saying.
No, I don't have much to add to that statement other than to agree with you. That's exactly right. And I think it's just building confidence in the system over here. As people get confidence, they realize that what you just described works, and that it's worth frankly, it's not that significant of an investment over.
Right. Well, and it's important when you're looking at this in advertising online. It used to be, hey, I want to track that cookie to see where that person was, so I'm going to spend that money on that $5 to get that click. But now, as Steve mentioned, if you're doing a full press of advertising, you're not going to necessarily be able to track where that person came from, but they might see your message on a YouTube video, they might see your message in Facebook, they might see your message on Google, and one of those might drive that actual action to your website to get that interaction, but you can't necessarily track it, which is why you have to go with that full court press.
I believe there's a question.
Walter's got a question.
My name is Walter Merricks, and I'm leading a major class action in this country against MasterCard, which will involve communicating with some upwards of 40 million consumers. So with Cameron's help, we're going to be notifying people in due course next year sometime of their right to opt out. Personally, I wouldn't advise anybody to opt out, of course, of my action, because that ways they're not going to benefit. But this will be the first opportunity for UK consumers to be exposed to this kind of notification of their rights. And I'm just conscious of the responsibility that I have to make sure that we don't mess this up. That we handle it sensitively, we handle it in accordance with the requirements of the tribunal, but that we don't confuse people into thinking this is some kind of scam, this is some sort of rubbish. There will be some people, of course, who will say, who will remember me from our past lives and say, Mr. Merricks, he's a dreadful fellow, and clearly he must be up to some no good. And so we will get all sorts of responses. And we'll have to be sensitive as to how we handle all that. The media, no doubt, I hope will be helpful to us. But it'll be difficult almost to judge how much do we want to engage response, or do we not want to engage response. So there will be lessons learned out of our experience that I hope others will be able to take forward. But as I say, I'm very conscious of the responsibility on my shoulders to make sure that those who come after don't look back and say, God, Merrick's messed that whole damn thing up. If he'd handled it better, then we would all have better prospects of bringing class actions, opt-out class actions, and managing them. There'll be further stages, I hope, in the process, but the first thing we've got to do is to notify people of their opt-out rights.
Well, I was excited to meet you last night, Mr. Merricks. That's something that we talked about, was how we can put that on Top Class Actions UK and work on that education side to help put out the positive message here of how this helps the individual UK consumers. And of course, as we talked about, saying this isn't a scam, because that's one of the biggest questions we get from people is, why am I going to give you my information? And sure, you're promising me money, but if someone promises me money on the internet, it's a scam. No, this is all legitimate, so please take part. So thank you, Mr. Merricks.
And listen, no matter how good a job anyone on this panel does, there is going to be a certain population of people on the internet who will tell other people it's a scam, who we have a whole team that monitors comments to the ads and responds to them, and we'll point them to the court documents and we'll show them the judge's order, and they are still out there vocally calling this a scam. So just in the event that there are people doing that, I don't think it should be a reflection of anyone's work. There's a certain population that's predisposed just not to believe this stuff, and you're never going to be able to get over that in its entirety. That just existence.
Yeah, that's absolutely right. You know, I want to make a point really quickly of what I think is better with the Consumer Rights Act is the fact of having the named plaintiff be somebody like Walter Marks.
Yes.
I'm not saying the U.S. system is bad or anything, but it's just different. You have the named plaintiff; they're just a class member, which I get the reason for. But having someone like Walter Marks involved ensures that the attorneys are being kept honest, and that we're being kept honest in the process, and it lends credibility to the whole thing. It's just much better, and so that part I really appreciate.
I couldn't agree with that
Yeah.
statement more. It's instant credibility.
Yeah.
In fact, what a lot of firms are doing now, even if their lead plaintiff, and most times their lead plaintiff is a known commodity, they're hiring professional spokespeople, which is something that we don't see in the United States. And I think it's a really interesting development. And we've only dealt with one or two cases on my side where this has happened. And I know there's been a couple of other organizations that have done this, but resoundingly, I've heard very positive results from hiring the appropriate spokesperson that has some sort of a tie to the case.
So I know we're getting close to the end here. Are there any other questions, maybe from someone who's attending virtually, or?
Hi, Mitesh Moda calling from Woods for Litigation Funding. Just speaking to one of the concerns that the funders had earlier, which is about the book build risk. And they talked about the risk of potential claimants signing up for multiple actions. I wonder what you guys thought about that and how that can be guarded against, because that is one of the concerns that we have when we look at the book build cost and the risk of there being kind of multiple sign-ups.
Well, from our perspective is we want to encourage as many legitimate claimants as possible. And so we try to make it very clear that if you're signing up for a potential case, that you qualify. And we reiterate multiple points during the sign-up process. If you don't qualify, please go away. But are you going to have people that are going to have duplicate submissions? Yes. But for the most part, we found that people don't want to go through the process unless they actually do qualify. There will be a very small number that could be potential fraudulent, but especially once you have to have an Epiq or an Angeion involved, they do a really good job at weeding out those potentials.
If I could speak to that as a more practical matter, when we're designing our websites in the UK and you're being asked to sign up, there's always screening questions that are specific to the case. Did you own this product during this time period? But one of the other screening questions that we make people attest to under oath is that they haven't signed up with another firm. Now, certainly, could someone lie? Absolutely. I know that so far, from my experience, a lot of the firms on the steering committee have been very good about sharing information, deduplicating between their lists, and making sure that there is some formula in place, whether it's first firm that they signed up with, or last firm they signed up with, or a split on the fees, depending on how many different firms they did sign up with, et cetera. It's never going to be a perfect system, but you can do very small changes in the user design of the website and what they have to go through to qualify, to let people know that it's a very serious offense to sign up in multiple places, and do everything you can on the front end and the design end to minimize that.
Yeah, if I could add a little bit to that, I'm intimately familiar with this issue of what we call dual reps. There's only so much you can do, like Stephen and Scott are alluding to. At the end of the day, some people may not know, some people may know and intentionally do it. In our experiences, we've had anywhere from 5 to 15% be the range of dual reps in the line of work that we do. We have seen some litigations scale to the likes of 25% in recent history, something like a Zantac here in the States that's an ongoing mass tort. Until there is a central suppression list, this issue will not be resolved. It will just be too complicated for attorneys to settle between their firms, split fees, that cuts into economics, ROIs go down, and now you have an issue. So I do think this is an ongoing obstacle that technology will need to get more involved with in order to solve. And a suppression list would certainly do so, some type of central database, but you do run into issues, at least in our experiences, with some of the systems of record that are in that position are having to appease multiple parties, defense, courts, plaintiffs. And so you start getting into privacy issues, data issues in terms of being able to ping that database, return such a unique identifier such as a last four of social or so forth in order to eliminate or cross-reference effectively.
So I'm cognizant of time. I think it's time for lunch. We're going to go to lunch. It's a cocktail party tonight. If you want to have any questions of any of the three of us that are here, we welcome that. Come up and give us a chat, and then or shoot Ty an email if you got a question for him off in Arizona. Thanks, everybody.
Thank you.
We appreciate it.